Chapter 5. The Use and Abuse of Analogies. 5.1 on Distinguishing Precedent from Analogy. It will strike some readers as odd that in an entire chapter on precedent, and then in another on legal authority, there has yet to be a single mention of the word analogy. Analogies, after all, are a ubiquitous feature of legal argument and judicial opinions. In law, as elsewhere, people argue that because some current situation is like another from the past, then the current one should be dealt with in the same way as the previous one. And because most analogies drawn by lawyers and judges are analogies to previous cases, it is tempting, as it has been for many commentators, to assume that the legal concept of decision according to precedent, which we examined at length in Chapter 3, is actually a form of argument by analogy, or even that the two are the same. The temptation, however, should be resisted. Although the use of analogies is pervasive in legal argument, analogical reasoning is not the same as constraint by precedent. The fact that lawyers routinely and loosely refer to any previous reported decision as a precedent helps foster the confusion. But a genuinely constraining precedent is different from a previous case that may be used analogically. In drawing analogies, we say that some aspect of a current problem is similar to some aspect of a past problem, and thus that we should learn sometimes to follow and sometimes to avoid from the previous event. When, for example, it was argued at the time of the First Iraq War, in 1991, that Saddam Hussein was like Adolf Hitler, the point was to show that because Hitler was a dangerous dictator who invaded other countries and needed to be stopped, it followed that Saddam Hussein, also a dangerous dictator who invaded other countries, needed to be stopped as well, because few people would have disagreed with the proposition that it was important to stop Hitler. Those who drew the analogy, especially President George H.W. Bush, hoped that others would agree that it was also important to stop Saddam. The analogical argumentative structure was the same for those who argued against the Second Iraq War in 2002, by using an analogy between that war and the war in Vietnam. Then the crux of their argument was that Iraq and Vietnam were both situations in which conventional warfare was impossible and in which American military knowledge of the culture, terrain, and language was minimal. Because Vietnam turned into a long, costly, and ultimately unsuccessful military venture, so the argument went, the similar situation in Iraq presented similar dangers and should therefore be avoided. This type of analogical argument pervades legal discourse. Consider, for example, the argument that prohibiting same-sex marriage violates the Equal Protection Clause of the 14th Amendment, because such prohibitions resemble the prohibitions on interracial marriage that the Supreme Court held unconstitutional in Loving v. Virginia. Here the formal structure of the argument tracks that of the Iraq examples above. A prohibition on same-sex marriage is similar to a prohibition on interracial marriage, because both prevent people who want to be married from marrying solely because of their immutable personal characteristics. The prohibition on interracial marriage was properly struck down. Therefore, following this logic, the prohibition on same-sex marriage should be struck down as well. Following the terminology of cognitive psychologists who study analogy, we can refer to the earlier case as the source or source analog, and the current case as the target. When a lawyer uses an analogy in an argument or a judge uses one in an opinion, the lawyer is claiming that some feature of the source case treating people differently because of their immutable personal characteristics, for example, is present in the target case, and accordingly the target case should be decided in the same way as the source case. Implicit in this standard picture of analogy is that the person drawing the analogy has a choice of source analogs and selects one from among multiple possibilities on the basis of its being the most useful in making a decision, or the most valuable for persuading someone else of the wisdom of a decision already made. Lawyers use analogies, therefore, because they are helpful. They assist in making decisions, they help persuade others of the correctness of decisions already made, and they illuminate aspects of a current situation that may otherwise have been obscured. So when the first President Bush analogized Saddam Hussein to Adolf Hitler in order to encourage support for the First Iraq War, and when opponents of the Second Iraq War analogized that war to the American misadventure in Vietnam, They both selected their source analogues Hitler and Vietnam, respectively, from among multiple potential candidates, because of the capacity of the ensuing analogy to persuade those who might otherwise have disagreed with their position. Although sometimes analogies are used to argue against rather than for some course of action that cigarettes should not be banned because of the lessons of prohibition, for example, or that the Supreme Court should not impose substantive as opposed to procedural constraints on legislation in the name of the Due Process Clause of the 14th Amendment, because of the unfortunate consequences of Lochner v. New York. Even here the analogies are chosen because of the guidance they are believed to offer, the illumination they are believed to provide, the lessons they are thought to teach, or the persuasion they are thought to facilitate. Those who use analogies do not select analogies that would prevent the selector, or the object of the selector's attempt to persuade from doing what would otherwise be to the selector a good idea. And decision makers do not select, or even see analogies that would impede a course of action that, but for the analogy, would be chosen. In other words, lawyers do not select analogies that they believe will not lead someone, judge or jury, to the conclusion that they are advocating. And judges do not select analogies that they believe will not help the reader of an opinion see the wisdom in their conclusion. As we have seen, however, the legal concept of precedent is very different. A mandatory precedent will sometimes, by virtue of its authoritative status, block an otherwise preferred current decision. The very fact that we refer to mandatory precedents as binding underscores their constraining nature, a constraint that operates precisely because the judge is perceived to have little choice in the matter. Law's use of precedent thus differs substantially from law's use of analogy, for in the latter, a previous decision is selected in order to support an argument now, while in the former, a previous decision imposes itself to preclude an otherwise preferred outcome. Consider Justice Potter Stewart's 1973 concurring opinion in Roe v. Wade. The most significant precedent was the 1965 case of Griswold v. Connecticut, invalidating a Connecticut law prohibiting the sale of contraceptives. For those justices who agreed with the outcome in Griswold, the result in Roe was largely unexceptional. From their perspective, Roe merely extended broad principles of privacy and substantive liberty set forth earlier in Griswold. Yet, although Justice Stewart had been one of the dissenters in Griswold, he did not dissent in Roe. He continued to believe that the Constitution contained no right to privacy, but he concluded that Griswold and other cases had, to his dismay, resurrected the doctrine of substantive due process, and he concluded in Roe that the obligation to follow even those precedents he thought mistaken mandated that he follow them in Roe, making clear that he then accepted the precedential authority of cases with which he disagreed. Examples of such crisp respect for stare decisis may be rare in the Supreme Court, but they are not unknown. In the 1950s and 1960s, for example, Justice John Marshall Harlan often joined the majority in criminal procedure decisions from whose basic principles he had dissented in previous cases, just as Justice Byron White in Edwards v. Arizona in 1981 felt obliged to follow the Supreme Court's 1966 decision in Miranda v. Arizona, a case in which he had been among the dissenters, and just as Justice Anthony Kennedy in Ring v. Arizona stated explicitly that, though it is still my view that the earlier case of Apprendi was wrongly decided, Apprendi is now the law and its holding must be implemented in a principled way. These examples come from the Supreme Court, but that is where we are least likely to find genuine precedential constraint. Because the Supreme Court hears and decides barely more than 70 cases a year out of the more than 9,000 petitions for review presented to it, and because even the 9,000 represent cases far along in the judicial system, the Supreme Court would be the last place to look for cases whose outcomes are genuinely constrained by a previous decision. As we saw when we examined the selection effect in Chapter 2, legal outcomes genuinely dictated by a rule or precedent are disproportionately unlikely to be litigated, or if litigated, appealed, and thus the population of appellate cases, especially at the Supreme Court level, is heavily weighted toward disputes whose outcomes are not determined or even very much guided by existing precedents. When we examine the United States Courts of Appeals, however, things are different. where appellate jurisdiction is a matter of right and not discretionary with the court, and where more than 80% of the decisions are not only unanimous, but also not thought deserving of even an officially published opinion. We find far more cases in which an existing mandatory authority appears to dictate a particular outcome regardless of what the judges believe might be the just or wise outcome, but for the existence of binding precedents. And thus, when we take into account the full universe of courts, the point becomes clear. The legal system's use of precedent is not about a lawyer or judge retrieving one from among numerous candidates for the source analog. Nor is it about using analogy to help a lawyer make an argument now or helping a judge reach a better decision now. Rather, it is about a judge's obligation to follow a mistake into her earlier decision solely because of its existence. It is, to put it bluntly, about a judge's obligation to make what she believes is the wrong decision. Stare decisis has no bite when it means merely that court adheres to a precedent it considers correct. It is significant only when a court feels constrained to stick to a former ruling, although the court has come to regard it as unwise or unjust. Perhaps the most striking difference between precedential constraint and the classic case of reasoning by analogy is the typical lack of freedom that a follower of precedent perceives in the selection of the precedent. Whereas analogical reasoners are widely understood to have a choice among various candidate source analogs, such freedom is typically absent with respect to the genuine constraints of precedent. Justice Stewart would have thought bizarre the suggestion that finding another earlier case could allow him to avoid the constraints of Griswold, just as Justice White would surely have laughed at the idea that feeling constrained by Miranda in subsequent interrogation cases was simply a function of not having been creative enough to select the best source case. Although it is true that on occasion creative and effective advocates can persuade a court to see a case or an issue in an entirely new light, far more often a previous decision about issue X looms so large that it is implausible for a judge to avoid that decision by maintaining that the current case is really about Y and not about X. In a very attenuated sense, no 24 forest green Toyota Corolla is the same car as any other 24 forest green Toyota Corolla. But there is nothing unusual when one owner of such a car says to another that, "I have the same car." So too here, any two previous cases, instances, acts, issues, or events are in some respects different. But in reality their equivalence is often inescapable. And in law and sometimes elsewhere, it is frequently both obvious and unchallengeable that the current decision to be made is about the same question that has been asked and answered on a previous occasion. Thus, it is characteristic of the ordinary instance of precedential constraint that the current issue is so widely perceived to be the same as one resolved in a prior decision, that it is not open politically or professionally for the current decision-maker to maintain that there is a relevant difference. A foreign policy decision-maker in 1991 might have been able with roughly equivalent plausibility to analogize Saddam to Idi Amin, a brutal dictator with whose country Uganda the United States did not go to war as to Hitler. But a Supreme Court justice asked in 2008 to rule on the constitutionality of a state law totally prohibiting abortion would find it virtually impossible logically, linguistically, psychologically, professionally, and politically to distinguish that case from Roe v. Wade. Once we understand that in the case of precedent, the choice of source decisions is often not perceived as a choice at all, and is often simply not a choice at all, we can grasp the difference between analogy and precedent. Whereas in the case of analogy, the lawyer or judge is looking for assistance in reaching the best decision or in persuading someone else of the best decision, in the case of precedent, the effect is just the opposite. When there is an unavoidable similarity between the source and the target, and when the judge, because of the constraints of vertical precedent or stare decisis, is required to decide the instant case, the target case in the same way that the precedent case, the source case, was decided, a judge will be constrained to reach what she will sometimes believe to be a poor outcome. Whereas in the case of analogy, a lawyer or judge is looking for a source case in order to help her make the best argument or the best decision now. With respect to genuine precedent, the judge will be compelled to make what she may believe to be the wrong decision. Analogy is hugely important in law, And good lawyers and good judges know how to use analogies effectively. But they also understand that precedent may on occasion constrain, and they understand as well that using an effective analogy and recognizing the constraints of precedent are hardly the same. 5.2 on the determination of similarity. That arguments by analogy are different from the constraints of precedent does not imply that analogical reasoning is unimportant in law. To the contrary, analogical reasoning is widespread throughout the legal system, and it comes as no surprise that many commentators have sought to explain the mechanism by which lawyers use analogies in making arguments and judges use analogies in justifying their decisions. And although the use of analogy in legal argument may not differ fundamentally from the way in which analogies are used in everyday life, and although analogical reasoning may be as ubiquitous outside of law as within it, analogies are still so common in law that it is important to examine more closely the structure of this widespread form of legal argument. The crux of an analogical argument is the claim that some act or event or thing that we encounter now is similar to something we have encountered previously. In law, the typical use of analogy involves an argument by a lawyer or a justification of a result by a judge that the current case is similar to another case in the past. But then we must confront the fact that any two things are in some respects similar, and in others different. My blue 2004 Subaru Legacy station wagon is similar to your blue 2004 Subaru Legacy station wagon in that they are both blue, both the same make and model, and both from the same model year. But they are different in that one is mine and one is yours, and they almost certainly differ in the number of miles they have been driven, and in at least some aspects of their mechanical condition. Likewise, there are obvious differences among black cats, black widow spiders, and black ink, but they are similar in all being black. If any and every two things are in some respects similar, and in others different, then how can we say that one thing is analogous to something else? Isn't one thing analogous to everything else, and nothing else just because it is similar in some respects to almost everything else and different in some respects from absolutely everything else? So is it not therefore true that any current case is similar in some respects to vast numbers of previous cases and different in some respects from every one of them? And if this is so, then how can an argument from analogy even get off the ground? Let us return to the example we used in discussing precedent in Chapter 3. Suppose reversing the actual chronology that it were to have been argued in Macpherson v. Buick Motor Company that the hypothetically previously decided English case of Donoghue v. Stevenson was analogous to the situation presented in Macpherson, and thus that the New York Court of Appeals should decide Macpherson in the same way that the House of Lords had decided Donoghue. Obviously, this is not a case of binding precedential constraint. No one would dare suggest that the New York court should decide a case in the same way that the English court decided the same issue because of some mysterious authoritative status of an English case. Simply put, the Macpherson court would have been under no obligation at all to treat Donoghue as binding or in any other way authoritative. But the lawyer for Macpherson might still have argued that the New York court should be guided by the English court's analogous, he would have said, decision in favor of Donoghue. In order to make the argument, however, Macpherson's lawyer would have had to demonstrate that the two cases were in some way similar, and Buick's lawyer would have argued in response that they were different. Macpherson's lawyer might have claimed, for example, that both Donoghue and the case before the New York court involved consumer transactions, that both involved products whose defects could not easily have been identified by the consumer, and that both involved manufacturers whose ultimate aim was to sell products to consumers, albeit through an intermediate retailer. Because of these similarities, Macpherson's lawyer would have argued the New York court should follow the lead of the English court's decision in Donoghue. In response, Buick's lawyer would then have pointed out that the Buick dealer could have inspected the car before selling it in a way that the retailer of a closed opaque beverage container could not have, that occasional defects in automobiles are to be expected in ways that decomposed snails in ginger beer bottles are not, and that the typical buyer of a car, especially in 1916, had the ability to bear the loss in a way that the typical patron at a cafe did not. The most important thing to be said about this scenario is that both lawyers are right. There are indeed similarities, and there are indeed differences. But not all of the similarities are relevant, and not all of the differences are relevant. In a case subsequent to Macpherson, it would be a bad argument that an identical situation involving a Ford rather than a Buick represented a different case, although of course Fords are in some respects different from Buicks. And in a different subsequent case, it would be implausible to argue in a breach of contract action by a supplier of parts against the Buick Motor Company that because the Buick Motor Company had been liable in Macpherson, it should similarly be held liable in this case, although the identity of the same defendant in both cases means that in at least one respect the two cases are similar. What distinguishes the good arguments from the bad ones, therefore, is not that the good arguments are based on similarity, whilst the bad ones are not, because both are based on similarity. Rather, the good arguments appear to draw on a relevant similarity, while the bad arguments draw on similarities that are not legally relevant at all, even if those similarities might be relevant for other purposes. So when a lawyer argues that gun dealers should be liable to anyone injured, or to the family of anyone killed by a gun illegally sold to a minor, he is likely to draw an analogy to the fact that sellers of alcoholic beverages, especially to minors, are often liable to those injured or killed as a result of the actions of an intoxicated purchaser. In this case, the argument is not an argument from precedent in the conventional and strict sense, because there are sufficient differences between the two cases that no judge would be faulted on grounds of failing to follow precedent for refusing to extend the vicarious liability rule for sellers of alcohol to vicarious liability for gun dealers. Rather, the argument is based on the premise that the judge is assumed to think that vicarious liability for bars is a good idea, and that there is sufficient relevant similarity between this issue and a previous issue that the judge thinks was correctly resolved to believe, or at least hope, that the judge who is sympathetic in the alcohol case will be persuaded because of the analogy to be sympathetic in the gun case. Yet although sellers of beer and sellers of guns may in some respects be similar, in others they are not. Beer and guns are, after all, very different, and so are the typical circumstances in which they are sold. So when there are obvious similarities and obvious differences, the lawyer who has chosen one analogy rather than some other is relying on something that makes the similarities relevantly similar. In 1978, for example, the American Nazi Party sought permission to stage a public march in the streets of Skokie, Illinois, a community disproportionately populated by survivors of the Nazi Holocaust, in arguing that public demonstration cases involving Nazis were relevantly similar to the public demonstration cases involving the civil rights protesters of the 1960s. The lawyers for the Nazis drew on some similarities, an unpopular group with a small membership seeking to protest against the views of the majority, while the lawyers for Skokie drew on the obvious differences between Nazis and civil rights demonstrators to argue that this was a bad analogy. Just as the lawyers for the Nazis argued that a judge who thought the civil rights demonstration cases had been rightly decided ought to rule for the Nazis because of the relevant similarities between the cases, the lawyers for Skokie argued that even a judge who thought the civil rights cases had been properly decided had ample grounds to refuse to analogize those cases to one involving Nazis because of the presence of relevant differences. As with the argument in the Skokie case, and as in countless other cases, analogical argument in law will involve arguments about which similarities and which differences are or should be legally relevant. The lawyers for the Nazis would argue that the point of the First Amendment is to protect unpopular views and groups, and thus the unpopularity of the civil rights demonstrators and the Nazis was the relevant similarity. In response, the lawyers for Skokie would argue that in the Nazi case, but not in the civil rights cases, the marchers intended to cause emotional distress to the observers of the march, and thus the cases were relevantly different. When these arguments about the relevance or irrelevance of various similarities and differences arise, the determination may hinge on the extent to which a previous case, especially a controlling one, has announced which similarities are relevant and which are not. Thus, the more the question of legal relevance has already been settled by a general rule, as with the rule emerging from the civil rights demonstration cases that marches, parades, and demonstrations may not be restricted because of the viewpoint espoused by the demonstrators, the more an argument from analogy will turn into an argument from precedent. The Nazis won in Skokie, although the march never took place because the Supreme Court had said in earlier cases that the viewpoint of the speaker, no matter how abhorrent, was not a legally relevant factor. But the more the determination of legal similarity and difference remains an open question, the more an analogical argument in law will resemble the analogical arguments that are used in all walks of life. If the civil rights cases had been decided with a less explicit statement about which factors are relevant and which not, and if the civil rights cases had been decided by a court in another jurisdiction, rather than by the Supreme Court, the question, like most questions involving dueling analogies, would have been settled by the determination of which of the analogies seemed more persuasive to the judge deciding the case. In this respect, analogical reasoning in law is important, but its importance resides in its pervasiveness, and not in its distinctiveness to or in law. 5.3 The Skeptical Challenge. Although lawyers and judges use analogy all the time, and although analogical reasoning in the law has been analyzed, explained, and celebrated in numerous books and articles, there is an important challenge that needs to be considered. This challenge does not deny that analogical reasoning exists, nor does it deny that analogical reasoning is widespread in legal argument and decision-making. What the challenge does deny, however, is that there is very much of deep importance in differentiating analogical reasoning from various other forms of decision, making according to a legal rule or according to a policy. So consider again the analogy between dram shop liability to victims of unlawful or negligent alcohol use and gun shop liability to victims of unlawful or negligent gun use. We have seen that there are similarities, and there are differences between the two situations. And we have seen that the ability to conclude or argue that the latter is analogous to the former is a function of the existence of relevant similarities that are perceived to outweigh any relevant differences. But where does this determination of relevant similarity come from? According to the skeptics, it derives from a determination of relevance that can be found in one of two places. It can be found, sometimes, in a statement in the earlier case, as when the Supreme Court in the civil rights demonstration cases of the 1960s justified protecting the demonstrators under the First Amendment against state restriction on the grounds that neither the unpopularity of the group's views nor the likelihood of a violent audience reaction to those views could justify restricting those who would otherwise be exercising their First Amendment rights. The Supreme Court having said as much explicitly, there was then a rule that made the moral reprehensibility of the American Nazi Party legally irrelevant. And there was another rule that also rendered the possibility of hostile audience reaction equally irrelevant. Deciding the Skokie case involving the American Nazi Party in 1977, therefore, was simply a matter of applying the rule set forth in earlier cases to this situation. There was indeed an analogy between civil rights demonstrators and the Nazis, the skeptics acknowledge. But the analogy, so the skeptics insist, did not determine the result. Rather, the analogy reflected or embodied the rule that the Supreme Court announced in the cases of the 1960s. At times there will not be such a clear and pre-announced rule, but the skeptical challenge still persists. If the Supreme Court had simply announced in the 1960s that civil rights demonstrators were protected by the First Amendment, and if the 1977 Nazi case then arose with only the civil rights cases having been decided, the court in the Nazi case would then have had to decide for itself whether the similarities between the civil rights demonstrators and the Nazis were more important for First Amendment purposes than the plain differences. And in doing so, the court would not have been able to say simply that the two cases should be decided in the same way, which was in fact the outcome because the Nazis were relevantly similar to the civil rights demonstrators, because that was exactly the matter at issue. Rather, the court would have had to come up with a rule or principle that determined what was relevant and what not. And in coming up with this rule, the court would not have been engaged in analogical reasoning, but would instead have been simply deciding what, as in any other case, on the basis of policy, principle, or something else, the rule ought to be. A principal motivation for the skeptical challenge is a worry on the part of the skeptics that often the court in the second case is pretending that the analogy pre-exists the rule that determines relevance, when it is in fact the other way around. The rule determines the analogy, but the analogy does not determine the rule, and pretending that the analogy is doing the work that the analogy itself without the rule drives. The result masks the fact that the second court is choosing the rule that determines relevance. To the skeptics, the problem is that the second court is making a choice, but acting as if some natural and deep similarity is dictating the result. The impetus for the skeptics, therefore, is that too much of the praise of analogical reasoning in law is a disingenuous celebration of what is in reality a quite creative exercise on the part of the second court. And although it may be too late in the day to object to widespread judicial creativity, and although there may be nothing at all wrong with judicial creativity, it may not be too late in the day to complain about the disingenuousness of using the language of analogy, both to avoid stating what the rule of relevance actually is, and to disguise the second court's creative choice with the language of seeming compulsion. There are a variety of responses to the skeptics, but all in one way or another accuse the skeptics of engaging in psychological reductionism. Drawing an analogy is not just another deductive process, so it is said, and not just a matter of applying a pre-existing rule or even a newly created rule. Rather, the ability to go from one particular to another without the existence of a generalization joining the two is a common form of human reasoning, and it should come as no surprise that it exists in law as well. Consider the case of Adams v. New Jersey Steamboat Company, a New York case frequently discussed in the literature on analogical reasoning in law. In Adams, the question was the nature of the responsibility of the owner of a steamboat with sleeping compartments to an overnight passenger whose money had been stolen when, allegedly through the company's negligence, a burglar broke into the plaintiff's sleeping compartment. What makes the case interesting is that two divergent bodies of law were both potentially applicable. If the law pertaining to open sleeping compartments in railroad cars was applicable, then the company would not have been liable. But if the law pertaining to innkeepers applied, then the plaintiff would have been able to recover. The question was then whether the steamboat with closed passenger cabins was more like a railroad sleeping car or more like a hotel. The court in fact decided that the law of inns and not the law of railroads should control. But the skeptics would not see this as an example of analogical reasoning. They would imagine that the judge had in mind a rule, even if it stayed in the judge's mind and never appeared in print, that would have established the similarity between the steamboat compartments and the rooms in an inn. But in deciding that the steamboat was more like a hotel than a railroad sleeping car, the response to the skeptical challenge would go, the court did not first imagine what, on the basis of policy or principle, the best rule would be, and then determine similarity on that basis. Rather, it looked at the two possibilities and simply saw more of a similarity in one direction than another. This might in theory have been reducible to some rule, but the rule did not consciously exist in the minds of the judges at the time they identified the similarity. So in fact for the judges the identification of similarity was a primary mental activity. And the non-skeptics insist that the judges were doing something that people do all the time in professional and non-professional decision-making settings. As the very title of a leading book on analogy, Mental Leaps, makes clear, ultimately, the debate between the skeptics and the traditionalists, if we can call them that, is one to be determined in part with the assistance of cognitive scientists, and not solely by lawyers or legal philosophers. It is a debate about how people think, and thus the debate is one about whether people always start with something general, and then apply it to the particular, as the skeptical challenge at times appears to suggest, or whether people often start with more particular insights or intuitions, and then seek to explain them thereafter. If much of human reasoning involves this kind of intuitive and non-deliberative leap from particular to particular, then it is important to identify analogy as the way in which this kind of thinking and reasoning frequently manifests in legal argument. But if what some view as an intuitive leap from particular to particular is actually mediated by constructing a generalization at some level of consciousness, then much of the celebration of analogical reasoning in law will turn out to be on psychological thin ice. And not only will the claim be psychologically shaky, it will also represent still another chapter in the long history of lawyers and judges denying the degree of genuine creativity and lawmaking that pervades legal decision-making, at least in common law jurisdictions. Even if the skeptical challenge is in the final analysis sound, it is not a challenge to the fact of analogical reasoning in law. It is a challenge only to claims of analogical reasoning's distinctiveness. And in the end, this debate, like many others, may not be one that has clear winners and losers. By understanding the debate, however, we may be able to understand not only the central importance of a relevance-determining rule in making the analogical process work, but also the importance of knowing when that rule pre-exists the drawing of the analogy, and when, at least in the eyes of the decision-makers, it does not. 5.4 Analogy and the speed of legal change. Apart from the questions of whether analogical reasoning is distinct from precedential constraint, and whether analogies are truly distinctive or merely something else in disguise, there is the normative question of whether analogical reasoning, especially by judges, should be embraced or avoided. In particular, it is sometimes argued that analogical reasoning is by its nature incremental, and thus that analogical reasoning is the vehicle of slow, rather than speedy legal change, of proceeding by small steps, rather than in large chunks, and of making legal changes against the background of leaving most of law, and even most of the law on that topic, unchanged. This variety of incremental change is often described in terms of case-by-case decision-making, the message being that change should be made only when there is a concrete dispute before some court presenting the opportunity for that change, and only insofar as is necessary to resolve that dispute correctly. And because reasoning by analogy requires that the current decision be connected in some way with the previous decision or decisions, operating analogically is of necessity a way of proceeding incrementally, and thus of proceeding more slowly. It is, of course, not always a good thing to proceed slowly, but the question of when it is desirable to proceed slowly, and when it is not, involves the full scope of normative political, moral, and legal theory. But assuming that it is at times desirable for the law to proceed slowly, there remains the question of how analogical reasoning relates to achieving that end. As we saw in the preceding section, what is an analogy is not a question that can be answered strictly as a matter of logic, because any two items, events, acts, or decisions are similar in some respects and different in others. And as long as this is so, then there is no a priori or logical reason to believe that analogical leaps must be small rather than large. Strictly as a matter of logic, Macpherson v. Buick Motor Company could be found analogous to any case against the Buick Motor Company, any case involving cars, or any case involving sale of products to consumers. So too could Raffles v. Whitchelhouse be understood as the source for any of a number of analogies about ships, about cotton, or about mistakes of any kind. And Rylands v. Fletcher might be analogous to any case involving water, flooding, land, or dangerous conditions. In practice, of course, this is simply not so. To take Macpherson as analogous, or as a stepping stone to a decision holding all manufacturers of consumer products strictly liable for all injuries caused to all consumers of those products, would strike us as implausible. And that would be so even if we could construct an analogy in which the move from the result in Macpherson to blanket strict liability for all manufacturers of consumer products was as logically impeccable as the move from Macpherson to a case like Donahue v. Stevenson. The analogies that are in fact persuasive and analogies are usually designed to persuade strike us as somewhat more deeply connected, as dealing with things that seem more deeply similar. Whether this is so because of the way people think, or because of the way in which parts of the world just happen to have been constructed, is a question more psychological than philosophical. But it is at least possible that to think analogically is to think in ways that build on what we perceive as pre-existing similarity. To the extent that this is so, proceeding analogically may turn out to be a more incremental and deliberate approach to legal change than some number of alternatives. But it might be important to bear in mind that this may be far more a matter of patterns of thinking that could be otherwise than of a strictly logical necessity.